converged for the 2024 National Summit on Justice at the National Judicial Institute, Abuja. Vice President Kashim Shettima, Senate President Senator Godswill Akpabio, and the Chief Justice of Nigeria, Justice Olukayode Ariwola, lead the three arms of government to the summit, which focuses on repositioning the justice system. The Minister of Justice and the President of the Nigerian Bar Association set the tone for the discussion, which is the advancement of the sector and implementation of the national policy on justice.
The policy seeks to promote and protect human rights and access to justice, which are essential features of a functional justice system. It proposes critical and sustainable interventions in the implementation of statutory provisions, encouraging protection of human rights and access to justice.
The position of the judiciary is no less the position of any of the security agencies. Because if you do not deliberately invest in the judiciary, then you are ignoring the very fabric, the very foundation on which this country stands.
This call is buttressed by the Chief Justice of Nigeria. He underscores the importance of rebuilding the trust of Nigerians in the judiciary.
The quest for justice should not be a privilege reserved for the few, but a right accessible to all, regardless of their circumstances. Therefore, it is incumbent upon us to embark on a journey of comprehensive reform to ensure that justice is not only dispensed, but also perceived to be dispensed fairly and impartially.
The Senate President has some recommendations for the judiciary, especially as it concerns political cases.
We must try and curb the misuse of ex parte orders in political matters, particularly by our judges, by the judiciary. To curb this, it is imperative that the National Judicial Council, the NJC, exercises stringent oversight. We recommend prompt and decisive punishment. Oh, I was going to say for judges, but maybe for the officers involved, who are found to abuse this authority in any manner.
President Bola Tinubu, who was represented by Vice President Kashim Shettima, urged the judicial officers to work towards strengthening the judiciary and be accountable to Nigerians.
The impact of their reform efforts should be visible in terms of improved access to justice, strengthen integrity of justice sector institutions, increase timeliness and quality of justice delivery, accountability, and transparency of the system.
The focal point at the 2024 National Justice Summit is accountability and transparency. Many Nigerians are expecting the arms of government will match words with actions. Emanuela Ekele, Channels Television News.
Let's begin today with that conversation around the justice sector reforms, which is an issue that's been on the burner for quite a while. As you saw earlier, Mr. Wahab Shittu joins us this morning. He's a senior advocate of Nigeria. Thank you for joining us today.
Thank you for inviting me.
Perhaps we should quickly begin with that ongoing conversation about the EFCC and the former governor of Kogi State. What do you make of it? There are those who have said the way the EFCC went about it was wrong. There are those who are arguing whether or not it's a case that the EFCC should have been involved or not, been involved in or not. There are those who are also saying, why don't the governor just do what the Attorney General has said? Present yourself to the EFCC and we'll deal with the other details later.
I think my response will be that how do we perceive what EFCC is doing? Is it in our collective national interest, or is something that we should wish away as unnecessary? I think we all agree that what EFCC stands for is in the overall national interest. EFCC is a statutory body created by law to deal with the phenomenon of economic and financial crimes. And so everybody should support it. The high, the low, all Nigerians should give EFCC all the necessary support EFCC is our collective enterprise.
Yeah, we agree, but the challenge is the question of whether or not it's a financial crime or it's a corruption case, which in this case would be the business of the ICPC.
You see, the functions of EFCC and ICPC overlaps. When you talk of economic and financial crimes, you are also talking of a species of corruption. You understand me? What EFCC is doing, what ICPC, both of them are working towards the same goal, combating corruption in the land. I think the answer is simple. Let us recognize the fact that no matter how big anyone is, the law is bigger. We operate a democracy by the rule of law. All are subject to the rule of law. Whether you are a governor, whether you are an ordinary citizen, whoever you are, so long as you don't enjoy immunity, then you must answer when the law calls. So I think that we should leave it at that. I don't want to prejudge anything.
Well, I understand that, but
yes.
perhaps maybe just this one thing.
Yes.
From what you said now,
yes.
If the ICPC and the EFCC seem to be doing similar work, are you saying they should be merged?
Well, it is for the authorities to decide what they want to do in terms of merger or what. But you see, the functions of each of them is specified in their enabling status. What I'm saying that in generic terms, both of them are dealing with the issue of corruption. You understand what I'm saying? And we all know that corruption is the elephant in the room. So if you need to create as many agencies as possible to deal with this elephant in the room, why not? Well, right? So, but whether we need to centralize a single body, it's also one of for justice reform.
Well, talking about justice reforms, is this something, are such mergers likely? Perhaps in the light of what you just said now, we recall the president talking about implementing to some measure the Oyonsari report. Do you think this justice reform program ongoing right now is something in that light?
Of course. The Oyonsari report, by popular acclamation, is a studied report, and I'm glad that the government is looking at that in that direction to see how we can implement the recommendations contained in that report to deliver efficiency and effectiveness in our administration generally.
Now, let's speak specifically to the issue of reforming the justice system. A lot has been said from the meeting of yesterday. The vice president speaking for the president, the president of the Senate making his own statements and all of that. And of course, the CJN also making his own comments. Which of these issues raised so far by these heads of the three arms of government stands out the most for you? Well,
I think first of all, we need to commend the Attorney General of the Federation for putting in place this summit. It's like walking the talk. He promised he was going to ensure that there's reform of our justice system. And it's really walking the talk. To that extent, we need to salute it. Well, it's a stakeholders problem. Reforming the justice delivery system is a stakeholders challenge. All stakeholders in the administration of justice must key into the agenda. Stakeholders at the level of the judiciary, at the level of the National Assembly, at the level of the executive, and even critical agencies like the prisons, the police, or including non-governmental organizations. We all need to key to this agenda. And in keying to this agenda, we need to answer 5 basic questions. Why? Why do we need to reform the justice delivery system in Nigeria today? First of all, we need to reposition our justice delivery system. Secondly, we need to ensure that we have constitutional reform, statutory reforms, and even operational reforms of the judiciary. We need to ensure that our judiciary is seen to be more transparent, more accessible, more fair. There's fairness in our justice delivery system. The challenge is how accessible is our judiciary to all and sundry. We also need to engender public confidence in our justice delivery system. We need to ensure access and efficiency in the way the justice delivery system conducts its affairs. And of course, we need to deliver on speed and transparency. And then there's also the need to ensure that there's increased budgetary allocation to the justice delivery sector in order to be able to enhance their performance. Those are some of the reasons why we need to reform our justice delivery system. Now, what are the problems? Some of them have been highlighted. One, there's delayed trials and backlog of cases. Secondly, there's alleged, the Chief Justice of the Federation, alluded to it, alleged corruption and inadequate infrastructural facilities and resources. For limited access to justice, especially for those in the rural areas. And then we have incidents of human rights violations, unlawful detention, torture, and how to deal with that. Inefficient investigation and prosecution of cases. We have issues of overcrowding and poor prison conditions, limited judicial independence.
Quite a lot of issues.
Yes.
Let's speak quickly to that independence that you talked about. I think it was last week we were having this conversation, or was it earlier this week? We were having this conversation with two gentlemen. And one of them, particularly a former AIG, was saying that interference of the judicial or the process of the judiciary is a problem for the police force, that they arrest someone or they put someone in, and they begin the prosecution of someone, and then from somewhere, some call will come. Does that, when you say interference, is that the kind of interference you're alleging? Are you saying that sometimes even judges are compelled to drop cases or judge in a particular favor?
I think we must be frank to ourselves. Incidents of political interference, elite interference.
On the judges?
On the process generally.
At what point?
At all stages of the process. And what the CJN alluded to that. Allow the judiciary to do its job. The judiciary is a very important arm of the government in stabilizing our democracy. If you want to enhance constitutionalism, enhance respect for rule of law, enhance respect for rights protection, accountability and transparency, and even deliver good governance, in all of these processes, it requires the judiciary. So you should allow the judiciary to perform its functions with little or no interference. Some of the calls that you have alluded to is unnecessary. When cases are submitted for adjudication by the judges, the expectation worldwide is that the judiciary must be allowed to do its work, devoid of interference, devoid of intimidation, devoid of blackmail.
Mr. Shittu, there are those who would also say sometimes, because when I hear people say the system is made of people, not machines. So is there a way, okay, maybe I should ask it this way, how vulnerable is the judiciary? How vulnerable are judges? How vulnerable is the entire judicial process in the country? And what makes us vulnerable?
Thank you. Well, let me say for free that in spite of all the imperfections, our judiciary still remains the best, not only in Africa, but in the Commonwealth. But in spite of the fact that we deliver this impressive showing, these judges, for crying out loud, are human beings. These judges live within the society. These judges have associations, they have relations, and these judges to have I mean they operate within the society, and so elements within the society, directly or indirectly, are capable of mounting pressures on and putting pressure on our judicial officers. But I'm happy to report that majority of our judges resist these pressures, in spite of the challenges that they face. Challenges of inadequate infrastructure, challenges of inadequate resources, challenges of inadequate remuneration. The environment under which they work are not conducive. In spite of this, they still deliver justice.
Well, it's there's something that that is common in the judiciary or judicial parlance. Justice delayed is justice denied. Now, to some of the cases that we hear, particularly political cases or similar, cases, we hear a situation where even the CGN has complained time without number that judges should stop delivering conflicting judgments, giving conflicting orders. Is this part of the vulnerability?
Well, that is part of it. Judicial pronouncements ought to be certain, ought to be predictable, in line with settled legal principles. So when you have incidents of conflicting judgments, it's unhealthy for the system. It's something that, and I want to also inform you that the judiciary is aware of this problem and is dealing with it through internal mechanisms.
How? Because there are those who would wonder how effective that internal mechanism has been, particularly in this current case of the former governor of Kogi State, Yahaya Bello, where on the one hand a state high court gave an order, on the other hand a federal high court gave a conflicting order to that. That's the assumption that some people are making. And it's not the first time. Even in the current, the political dispensation that we have, we've had such similar cases as well. So how is the judiciary dealing with it when it is still persistent?
Well, the National Judicial Council, in its oversight, responsibilities, is dealing with it at that level. And then pronouncements have been made against such practices. And then mechanisms have been put in place to stem the tide. And then you keep on referencing this issue of Yahaya Bello. But I think it is clear that no court of law can stop a statutory body from, no one can stop anyone from being prosecuted except you enjoy immunity. That is elementary. If you are accused of any crime, go answer to it. That is so elementary. No court will say, oh, EFCC should not perform its functions. No court can say, okay, a court should be prevented from sitting. No court will say, we will stop the National Assembly from sitting.
So what then do you make of that order from the State High Court in Kogi?
Clearly, it is per incuriam. You know what I mean?
No, I don't.
I mean, it is delivered, that order was delivered in ignorance of the law. But you know that judges are entitled, they have jurisdiction to be right, as well as jurisdiction to be wrong. That is when, in cases where judges err, there's a mechanism for appeal. And that is why we have the highest court of the land, to correct incidents of, erroneous pronouncement. But I want to tell you for free that EFCC statutorily cannot be stopped from performing its statutory functions of investigation and prosecution of crimes.
Now, my colleagues in Abuja will take you up on a number of other issues, but in your response to this one, what do you make of the need for infusing technology? I mean, you've talked about the judgments in rural areas and areas where, those things, and it's not so easy to have access to justice. How will technology help? Particularly in the light of the fact that technology is a lot more recent than the law itself.
Thank you.
How do you see it?
Thank you. That is part of this reform agenda. And you saw the keynote address of the Senate President, also talking about that. In order to enhance speed, to enhance transparency, and also to bring our justice delivery system to be in line with best practices, we need to leverage on technology and digital tools in order to, ensure that our justice delivery system is prompt, takes advantage of speed, and other, advantages of technology. Technology will impact positively on the justice delivery system. For instance, most of our judges write in longhand, but through technology, you have devices like to record proceedings, and then make some of these. It encourages judges to be able to listen to testimonies without having to write in longhand and some other things. So there are various ways, even the filing system, filing of processes, and even virtual delivery of hearings, and some other digital tools can enhance the justice delivery system.
Interestingly, Mr. Shittu, I'm just wondering how that is going to... Are we also going to have judges dictate their judgments to technology? Don't answer that one yet. Let's take a short break, and then my colleagues will take it over from Abuja.
Thank you for staying with us, and welcome back. Mr. Shittu, I know you've made a couple of assertions in the course of this conversation today, but I just want to take you back a little bit. Yesterday we had a conversation here, and one of our guests mentioned the need to build institutions. In his assertion, he said that if institutions are not built, if the individuals are continually appearing stronger than the institutions, then we may not have the kind of systems that we want to have. You've talked about the judiciary, and one of the things you said was that the judiciary must be allowed to do its job. How can the judiciary be allowed to do its job if there are interferences? Because the institution of the judiciary is not strong in itself, in terms of equipment and resources with which to function effectively.
Thank you. One way the judiciary can be allowed to do its job is for us to deliver to the judiciary financial autonomy. The judiciary does not have to go cap in hand, begging for funds to service its operations. We must deliver not just physical independence to the judiciary. We must also grant to the judiciary financial autonomy. The judiciary should be allowed to draw funds from the first line charge. The judiciary should have its own budget. Unhindered, enough funds should be provided for the judiciary to meet not only operational expenses, but also, and then the judiciary must be well paid at all levels in terms of remuneration. And then the judicial officers must also be properly taken care of, even after retirement. There should be such incentives that will attract to the judiciary the best men and women. Because you cannot talk of democracy without rule of law. And central to the rule of law is the place of the judiciary. The judiciary, in fact, I dare say, is the most important tier of government in a democracy. Because that is if you talk of respect for constitutionalism, That is that is the terrain of the judiciary. Respect for the rule of law, that is the terrain of the judiciary. Independent electoral process, free, fair electoral process, that is the terrain of the judiciary. If you are talking of transparency and zero tolerance for corruption, that is the terrain of the judiciary. If you are talking of good governance, it is the judiciary that can hold all the tiers of government accountable to deliver effectively on good governance. So, judiciary, a democracy without respect for the judiciary, is not a democracy. In fact, that's the rule of the jungle. So if you want the new democracy, I'm not talking of cash and carry democracy. I'm not talking of the democracy by anointing. If we want real genuine democracy, then we must empower the judiciary. We must allow judiciary to be peopled by best men and women. You should not interfere in judicial appointments. Judiciary is not a place where you say, oh, I want to favor my, I want to favor those, I want to patronize some people and reward them with judicial appointments. That is not the place. You are not allowing the judiciary to function effectively when you interfere in judicial appointments, when you interfere in the way the judiciary conducts its business, when you blackmail the judiciary, when disputes are submitted to the judiciary, allow the judiciary to perform its functions. We saw what happened during the election.
If I may come in here.
In the aftermath of the election.
Mr. Shittu, if I may be allowed to come in here, the matter of financial autonomy is a conversation that's been on and on. I mean, around the year 2022 or thereabout, judiciary workers shut down all the courts because of implementation of financial autonomy. In other words, it's already there, but implementation is another part of it. But then some will say that those who are supposed to hold the executives, the leadership of the judiciary in itself is not even ready for the financial autonomy that they are asking for. Would you say that there's a problem with that?
Well, I want to disagree with you. I think it's elements outside the judiciary that are not ready to deliver to the judiciary financial autonomy. When we are talking of financial autonomy, we are not just talking of judicial officers alone. We are also talking of elements who service the judiciary, like judicial staff and judicial workers. And where the judiciary has made its representations in various fora, even to the legislature and to the executive, about the challenges. Everybody is aware about the peculiar challenges of our judice. It is not that they are not aware, but the question is walking the talk beyond rhetorics. For instance, the 2-day summit which took place in Abuja itemized 17 thematic areas for judicial reform. Are we ready to incorporate this into our constitutional framework in terms of amendments? So it is not that these ideas are not being put forward. Regularly, the stakeholders have been making, recommendations, far-reaching recommendations on how the judiciary can be made effective and efficient, how judiciary can be made more independent and autonomous. But the stakeholders, the ruling elite, are they willing to deliver to the judiciary what is rightly, due to the judiciary? That's the question. I listened to the Senate president. He said, beyond this talk, that the National Assembly has a lot of, there's a committee of the National Assembly on constitutional amendment. There's also a committee of the National Assembly on electoral reforms. They must translate some of the recommendations coming out of this 2-day summit into realistic policies and laws.
Mr. Shittu, if I may come in here, because on that particular point, that's where we're trying to build this on. You've talked about quite a lot of issues that have to do with the judiciary, interference, financing, but there was something else that you mentioned. You talked about that High Court judgment in
I hope I'm getting that right, that court judgment that came from Kogi State. And you said, I'm going to quote you right now, it was delivered in ignorance of the law. Now, for, you know, for a segment of our nation that's supposed to be, you said, the most important, how are lapses like this even possible? How can a judgment be given in ignorance of the law in a time when we're trying to deliver proper justice to all of the people of Nigeria who are looking to the judiciary right now to stand for them? How was this possible?
Thank you. If you look at our constitutional framework, we have three tiers of the hierarchy of the court system. We have the High Court, we have the Court of Appeal, we have the Supreme Court. It is because the system also recognizes that one person sitting as a High Court judge may make mistakes. And that is why there's a mechanism for appeal. At the level of the Court of Appeal, you have 3 justices coming to take a second look at what has been done at the level of the High Court. And if you are still aggrieved, you can proceed to the Supreme Court, where you have 5 justices, eminent justices. And if it relates to constitutional questions, 7 justices will be a panel to address the issue. It is because and it is after that decision at the apex court is final. So the High Court can make mistakes. Every judge has the jurisdiction to be right, as well as the jurisdiction to be wrong. And that is why we have a mechanism for appeal. So when I say judgment is delivered in ignorance of the law,
how do we stop judges from making these mistakes? This, Mr. Shittu, if you can hear me, this particular mistake, because that's what you've called it, a mistake. How do we check judges to make sure that they don't make mistakes like this? So it was a mistake, well, we can appeal it, you know, and whatnot. How do we stop judges from making these sorts of mistakes?
Well, there are various ways. First of all, ensure that the quality of judges that are appointed to adjudicate over our cases is very high. Nigerians parade some of the best legal brains, not only in Africa, but in the continent. I mean, in the Commonwealth. In the world, we are respected. We found elements from, you know, our system here, adjudicating even at the level of the International Court of Justice. We should ensure that in the appointment of judges and justices, we appoint the best in terms of knowledge, in terms of character, in terms of learning. Secondly, we must avoid interference in judicial appointments. Thirdly, our judges must constantly take benefit of training and retraining in order to align themselves with current state of the law and best practices. Fourthly, we must activate our disciplinary mechanisms at the level of the NJC to check judges who run foul of settled legal principles. Fourthly, we must accelerate the process of our appeal system to ensure that when mistakes are made at the lower court, they can be promptly corrected by the appellate court, taking advantage of speed. And that's why we need to ensure that our justice delivery system, you know, does not suffer unnecessary delays.
A quick one before we wrap this up. We've talked about the judges, justices, and the rest of them, but we have not talked about the legal practitioners, the lawyers themselves.
Yes.
Sometimes you know where this case is going, yet you file it anyway.
Yes.
We had a situation where one judge had to tell a lawyer, you know this thing is not going to fly. Why did you even, you know, make the move in the first place? So what do we do in that regard? Because sometimes they are the ones that literally put the judges, you know, in the line of fire, so to speak.
That's why I'm saying that when we are talking of reform or these problems, it's a stakeholders problem. It's not judges alone that you single out for blame, even lawyers too. That is why we should activate our disciplinary, you know, mechanisms. Judges, lawyers who make mistakes or who commit fundamental infractions can be brought to book through our disciplinary procedures. Again, beyond these reforms that we are talking about, we need a change in mindset. We need a change in attitude.
You're talking about Nigerians generally.
I mean stakeholders generally.
Okay.
In the administration of justice, there should be a change in attitudinal chemistry of our lawyers, of our judges, and of those who make use of the court system.
Okay. Well, that's a very tall order because, yes. I mean, attitudinal change is something that we've been talking about for quite a while, you know, on this program, particularly for every Nigerian. It's an ongoing conversation, and let's see how this whole reform system pans out in the coming days. Thank you so much for being here this morning with us.
Thank you.
Wahab Shittu is a senior advocate of Nigeria. We appreciate your time today.
Thank you for inviting me.